Hello and welcome back to Coin Lady channel. Coinbase, and possibly any cryptocurrency exchange that faces legal action from the SEC for suspending XRP trading, made a serious legal error by deciding to delist XRP from its trading channels. For over 2 years, I've been stating that I feel for Coinbase, which was put in the position of having to make a tough choice and trying to safeguard its employees. That's still accurate, by the way. That is how I feel even now. However, from a legal standpoint, and especially with the benefit of hindsight, it appears that this is going to come back to bite Coinbase in the behind. The fact that they done so undermines their case in court. And I'll tell you what XRP community member and attorney Bill Morgan thinks about it. And this is where things get interesting, though I should clarify something first. I come from no financial or legal background. Do not buy or sell anything based on anything I say or write. I'm not a licensed attorney or financial advisor. I'm just a fan that occasionally posts films to YouTube regarding crypto-related subjects for pleasure and as a pastime. Okay, then? So, the Cardano Times has provided a very brief Twitter thread right now. And lawyer Bill Morgan ended up retweeting this. So, I'm going to begin the video recording now. Read Cardano Times' take on Coinbase right here. Just so we're all on the same page, Coinbase did receive a Wells notice, which is essentially a preliminary notice stating, hey, we're going to sue the snot out of you. That pretty about sums it up. Is there a shot that the SEC won't sue Coinbase? In a strict sense, yes. Because Gary Gensler has the support of the Senate, I see almost no chance of that happening. That makes perfect sense to me. The Wells notification is, from my perspective, merely a formality. And you can expect a lawsuit against Coinbase. I suppose I could be wrong and it wouldn't happen after all, but I doubt it very much. This is where most people expect to end up. Coinbase has been in the news a lot recently, too. Therefore, I will not spend much time in depth discussing this in this video. Since Coinbase had the chance to respond, they did so by pushing back and providing the SEC with their perspective. Not that I think that will help them one bit, but kudos for making an effort. So, here's what the Cardano Times had to say about the news that Coinbase's CLO Paul Grewal had responded to the SEC's questions. Note that the firm has complete faith that the consolidated exchange does not offer any securities for sale on its website. Coins like Ethereum and Cardano are included in this category. Grewal's claim that Coinbase's rigorous process, based on SEC guidance, rejects over 90% of the assets is a bold statement made as the SEC cracks down on unleashing their legislatively dubious regulatory authority over cryptocurrency-based companies like Coinbase. The agency claims that most cryptocurrencies are indeed securities. It is the working assumption of the exchange's review process that the vast majority of unapproved cryptocurrencies may properly be categorized as securities. Okay, I think that clarifies things a bit. This is where things start to get exciting, by the way. So, attorney Bill Morgan criticizes Coinbase for removing XRP, and I think he does so fairly. That's why I simply told you that Bill Morgan retweeted that thread. The following is what he then penned. And its own conduct in listing, then delisting, and not relisting XRP undermines that statement as well as any assertion regarding its listing standards. The lack of listed securities at Coinbase belies the quality of its listing standards. Where did XRP go wrong? You don't think that will be used against Coinbase by the SEC, do you? If Coinbase admits it was an error, how can it deny making similar errors in the past? In regards to the other listed cryptocurrencies that the SEC has claimed are securities, such as Algorand and Dash. Whether it's a V or an SEC. I'm using Bittrex. If Coinbase continues to say that listing XRP was not a mistake and that it is not a security, the exchange might be accused of being inconsistent on whether or not to delist the cryptocurrency. This is an annoying issue that Coinbase created for itself. Okay, I'll show you a couple examples. In my opinion, he has hit the bullseye. Here are some of my thoughts as a layperson regarding this matter. And then I also have some further, very smart feedback from attorney Bill Morgan. But, look, an argument is a theoretical construct, so I'll just try to imagine what Coinbase might say in defense of its actions. Which is not to say that I endorse it. I'm doing the best I can. Considering how badly I messed up, what could I possibly say if I were in their position? One possible defense for Coinbase's delisting of XRP is that it was done so out of an abundance of caution. Since the SEC just finished an extensive investigation into Ripple, they may have data that Coinbase does not have. Right. The SEC could always ask Coinbase why it hasn't delisted at that point. Algorand and Dash are among the other coins we've identified as securities. And Coinbase might respond. Well, a couple of things in response to that. First, as evidenced by Judge Netburn's comments in SEC v. Ripple, they no longer have faith that the SEC is acting in strict compliance with the law. Since the SEC has already shown itself to be untrustworthy, there is no reason for investors to keep giving them the benefit of the doubt by assuming that perhaps they know something that we don't. And in principle, they would have a point. Second, they can argue that the SEC has not sued the producers of other coins that it has labeled as securities. So far, so good with Ripple. That's the claim, at least. It's very obvious that Ripple isn't responsible for developing XRP, but that seems to be what they are saying. That Ripple, it's the same thing over and over again. Instead, they decided to sue the exchanges. They targeted the marketplaces that enabled trading in these assets. And, I'm not sure one of those is actually an argument that would benefit Coinbase. That, however, serves to further illustrate my point. They've gotten themselves into a jam because they haven't been inconsistent enough. They certainly aren't incapable of attempting innovative ideas. I just did it without any prior planning. Just a few of quick notes because they were on my mind as I prepared to make this video. Okay, I suppose they're capable of that as well. And I'm not a lawyer, so I don't know how effective that would be. I'm just a regular guy sitting here trying to protect Coinbase as best I can, and I swear I'm not doing it because I want to or anything, rather, it's more of a mental challenge. And it's not really convincing to me. It's the best I could do. It's possible, that they might have something. If they hire a list lawyers, maybe they can invent something more impressive than the Moon family car. However, you're fine. They are, however, in a difficult situation. After sharing this, Attorney Morgan continues. There is a short video clip. That must have come from Coinbase, right? Yeah. That is, it does not follow that secondary market transactions implicate that investment contract even if each asset issuer were engaged in ongoing marketing efforts at the time of each transaction on Coinbase, and even if those ongoing marketing efforts were somehow viewed as sufficient to establish an implicit investment contract, e.g., as a scheme. On the other hand, Coinbase's secondary market trades violate all four of Howey's criteria. What I'm about to share with you is what Bill Morgan did with that statement and argument from Coinbase, which is, by the way, a sound argument, a very excellent argument, and true. And Ripple has been making the same convincing case, although not with respect to Coinbase per se but rather with regard to secondary market transactions and so forth. That's common knowledge among you. But what Attorney Morgan does is take this excerpt from Coinbase that you can see on your screen right now and apply it to the situation. And then he does something really clever. He utilizes as many of the original words from the argument as possible. Then he inserts Ripple and / or XRP wherever it makes sense to do so. When you consider the legal implications, it becomes even more ludicrous and egregious of a mistake that Coinbase delisted XRP. So, here's what Bill Morgan, an attorney, had to say about it. He stated, seriously, if Coinbase is going to run this argument in a defense to a claim by the SEC and mean it, then its decision to delist an ongoing decision to not relist XRP is an entirely inconsistent and inconvenient fact. For the sake of emphasis, let me reword the submission to make new references to Ripple and XRP. What I just told you is where he promotes Ripple and XRP. He argues that even if Ripple's ongoing marketing efforts coincided with each Coinbase XRP transaction and were sufficient to establish an implicit investment contract, it does not follow that XRP transactions on the secondary market are relevant to the investment contract. On the other hand, Coinbase's secondary market XRP trades fail on all four Howey criteria. There you have it. Cruel, Paul, and Armstrong, Brian. Either what you just said is total nonsense. I agree or think it's completely random and inexplicable that you disregarded the logic of your own wealth submission in regards to XRP. Do you really think the SEC won't take note? In the end, Brian and Paul can go any way. No. To the best of their knowledge, XRP exchanged on Coinbase is not a security, and vice versa. You guys can't play both sides in your answer to the Wells notice. Now he's got it right on the money. Yes, we're in a terrible spot right now. Also, there's this other thing to think about, because I believe Coinbase was giving in. Keep in mind that this occurred right around the time that Coinbase was attempting to go public. To use an IPO analogy, they were the top priority. Right? Because, to repeat, Ripple was sued in December 2020, and Coinbase held their IPO in April 2021, just a year later. Wouldn't keeping XRP listed have slowed things down? Perhaps that played a role, and now it's coming back to haunt them. Certainly, that's not out of the question. I wish I could have listened in on the conversations taking place about these issues in the hallways of Coinbase's headquarters. That's a fascinating thought. Perhaps, but we'll never know, that would have been taken into account. Unfortunately, XRP was the one thrown under the bus. Even after more than 2 years, I still feel some compassion for the situation. From a legal standpoint, however, their subsequent activities demonstrate that they have been consistent. You can tell that they're inconsistent. And the only thing you could say in response is something I said just a few minutes ago, that while the SEC did sue Ripple, it seems to be content to make the claim that other cryptocurrencies are securities without taking action against anyone involved in the ecosystem beyond the exchanges. That's a clear distinction, all by itself. You don't see it as wrong, either way. Coinbase. Oh, I see. Okay, now I see it. Okay, now I see it. It will be intriguing to observe how they attempt to squirm their way out of this situation. Whatever the hell they are going to quarrel about, I'm sure we'll be discussing it as soon as we see it, as it's likely to come up sometime. I don't claim to be a financial expert. My words here should not be used as a basis for making any financial transactions. Please like and subscribe my channel. See you later, bye.